Good morning and Gong Xi Fat Cai for all my friends celebrating Lunar New Year in Asia. I'm Gary DeWall, and this is Bridging the Week for February 1st to 5th, and today is February 8th, 2016. Last week, two firms agreed to pay substantial fines to resolve New York State and SEC allegations of wrongdoing by their dark pools. In addition, two U.S. futures exchanges issued helpful clarifications regarding their requirements regarding position limits and wash trades, respectively. Finally, both the heads of the CFTC and the UK FCA spoke about proposed new rules regarding position limits, but one strongly criticized her continent's proposed rules as quote-unquote not necessary. We've got some interesting and helpful articles this week, so on the first day of Year of the Monkey, let's stop monkeying around and get started. Barclays Capital Inc. and Credit Suisse Securities settled allegations by the Securities and Exchange Commission and the New York State Attorney General related to their operation of automated trading systems known as dark pools. The banks settled the allegations by agreements to pay penalties in excess of $154 million in aggregate to both regulators. The regulators had alleged the banks made false statements and omissions in the marketing of their dark pools. The regulators raised objections in connection with Barclays' automated trading system known as Barclays LX and Credit Suisse's ATSs known as Lightpool and Crossfinder. The Commodity Futures Trading Commission formally opposed efforts by Kraft Foods Group and Mondelez Global to formally appeal two legal issues to federal appeals courts in connection with the CFTC's enforcement against the defendants. Last month, the defendants requested permission from the federal court hearing the enforcement action to have a federal appeals court rule on two of the commission's central legal theories in advance of trial. These are whether a defendant's futures position coupled with an alleged intent to affect market prices, but absent any other false communications to the market, is prohibited false signaling manipulation, and whether the prices that result following a defendant's purchase of futures positions in a market that cause futures and cash prices to converge are artificial prices. In papers filed with the federal court, the CFTC argued that the defendants should not be permitted to file an appeal at this time because neither of the legal issues raised by them, quote, accurately reflects the factual allegations in the Commission's complaint, end of quote. Moreover, said the CFTC, even if the defendants were to prevail on both of their questions on appeal, the ruling would not end, quote, the market manipulation aspect of this case, end of quote. As a result, said the CFTC, defendants' motion did not meet, quote, the high bar set for interlocutory appeals, end of quote, under applicable law. NASDAQ Futures Inc. issued frequently asked questions related to position limits and accountability levels. In general, position limits on NASDAQ may not be violated at any time, including intraday. Moreover, no futures participant, meaning any person who is authorized to access the exchange's electronic trading system directly, may, quote-unquote, affect a transaction for any other person that the participant, quote, knows or has reason to believe would result in the futures participant, a customer, or any other person holding or controlling separately or in a combination, quote, a net position in violation of a position limit. If a clearing member carries positions for a customer in excess of position limits, NASDAQ Futures requires the FCM, quote, to discover and to liquidate such excess positions, end of quote, within one business day. NASDAQ Futures facts provide helpful guidance on understanding so-called diminishing balancing contracts, or diminishing balance contracts, where the front month volume in any given contract month ratably diminishes as the contract month progresses towards expiration. There's a lot more I say about NASDAQ Futures rule regarding position limits and those of other exchanges on the article version of Bridging the Week on the website. Check it out. ICE Futures US also issued a revised wash trade frequently asked questions to additionally address, among other topics, unintentional matching of buy and sell orders from the same principle, as well as the exchange's self-match prevention technology. In general, IFAS prohibits any person executing a wash sale. A wash sale, or a wash trade, is a transaction or series of transactions executed in the same commodity contract at the same or similar price for accounts with the same principal on both sides. IFAS Facts makes clear, however, that buy and sell orders that are placed by independent decision makers for accounts that reflect the trading of separate business units of the same principal that coincidentally match would not be considered a violation of IFAS's wash sale prohibition. However, in such instances, quote, the parties to the trade must be able to demonstrate the independent control of the accounts and that the transactions had a bona fide business purpose for each party to the trade, end of quote. On the other hand, IFAS indicates that if orders entered for a single automated trading system or various ADSs controlled by the same individual trader coincidentally match, resulting trades, quote-unquote, may be considered prohibited wash sales if such matching occurs, quote, on more than an infrequent basis, end of quote. Currently, proprietary traders who access IFAS directly using algorithmic trading applications are required to use the exchange's self-trade prevention functionality to help avoid such unintentional matches. There is a lot more I say about IFAS's rules about wash sales and those of other exchanges on the article version of Bridging the Week on the website. Check it out, too. In a speech last week before the Commodity Markets Council, Timothy Massad, chairman of the Commodity Futures Trading Commission, highlighted recent CFTC actions benefiting commercial end users. Among those included adoption of a rule amendment that exempted commercial end users that are members of exchanges from having to maintain certain pre-trade communications. Mr. Massad indicated, however, that the Commission is also working hard to finalize rules regarding position limits, but committed to no conclusion date. This is because, he said, quote, none of us currently on the Commission were in office when these rules were proposed, and therefore we are taking time to listen to you and other market participants and consider the proposals very carefully, end of quote. Separately, Tracy McDermott, acting chief executive of the Financial Conduct Authority, said that MiFID II's requirements to have position limits for every single commodity derivative traded in Europe, quote, is not necessary, end of quote. She also claimed that the practical, quote, practical details of position reporting were not adequately thought through, end of quote, in the negotiation of the directive. Ms. McDermott made these remarks in a speech generally supporting MiFID II before Bloomberg in the City of London. Well, that's it for this week's edition of Bridging the Week. As always, there's more information in each article, and more articles on the article version of Bridging the Week on the website. Check it out. Oops, gotta put my finger here. I'm Gary DeWald, and until next week, have a great week, enjoy your New Year celebration if you celebrate, and ciao.